Hi, I'm Vince White from White, Ricotta and Marks, and I'm here with one of our Attorney for the Teacher segments. Today we're talking about U ratings, unsatisfactory ratings under the new rubric for teachers in the Department of Ed and other school districts in New York State. There's been a lot of confusion about whether or not when you grieve your U rating, if you can have private counsel. Now, 3 years ago, we had some success getting in to represent individuals at the U rating. A lot of those individuals didn't want the union to represent them for various reasons, and they wanted us there, and we were able to do that. Then about 2.5 years ago, we started having trouble. I was escorted out of a building by security because I was there for the hearing, and they suddenly decided I couldn't represent my client for that hearing. Now, the law does seem to uphold them. It seems to require either a city employee or a union representative be there to represent you at that U rating. So we have stopped, and that's about 2 years ago, we stopped representing people at the U rating hearings, very different from the tenure hearings where we obviously do represent teachers. Certainly I see why they want outside counsel for that. So you're stuck to some extent. You've got to go with that union representation, even if it's not exactly what you want, or you don't feel confident in their abilities. I would suggest if you're having trouble with your individual union rep, ask for someone else. I mean, it's a pretty big union. You pay them a lot of money. I'm sure they can find you someone that you can at least work with, right? Another point for the U ratings that I think we should bring up is that there's some recent case law showing that receiving a U rating very late in the school year can now be viewed as a mitigating factor. If they don't give you time to respond to the U rating, if it's not a series of informals all notifying you that it's an unsatisfactory performance and you need to fix things, and instead it's just that final formal very late in the year, people have successfully argued they didn't have a chance to reform. This is very similar to the argument teachers have made, hey, you say I'm unsatisfactory and you want to strip my tenure, but you never gave me professional development. You never gave me a chance to reform. It's similar to that, only instead of saying you never gave me the courses, what they're actually saying is you didn't give me the time, let alone the courses or the coaching or whatever else they might offer you. They weren't even granted the time to respond, to reform their lesson plans, to work on their classroom technique. Who knows? There's a million things they might do. Maybe it's the billboard, the board where they post everything in the classroom, right? That seems to be a very common item that administrations attack because it's so discretionary. I don't like how you do your board. Okay. If there's a way you want that individual to do their board, why don't you share that with them? Then they can conform to that because you are the principal and they want to be a good employee, and we can all move happily along trying to make these kids learn, right? So again, the U rating, you can't bring in outside counsel as far as we can tell. We had no success doing it. We talked to other attorneys, they also have had issues, and the law does appear to hold that up. So it's very disappointing, but I hope that if you have a U rating coming up, you're working with your union, you're preparing, and if you have questions, please don't hesitate. We're always here to help. You can find our websites 3028.net or attorneyfortheteacher.com or queensemploymentattorney.com. I hope this helps. Take care.